Hello everyone, I'm Nisha Gautam, student ID ABN2177. Today we are here for our presentation of legal aspects, international trade and enterprise. The topic of our case is banning of salmon importation from Canada by Australia and the disputes between them. First, I'm going to have the introduction of what is international trade. International trade is a global business where a company doing business all over the world, and the thing we are discussing about in our case is the disputes that happens in and between the organization while having international trade. It is not sure that there will not be any problem while doing business, like it's two-party organization and there happens many disputes regarding the things in business. Like the same happened in our case. Suddenly Australia banned the importation of salmon from Canada, showing the reasons that there causes different problems in environmental problems, some infection, everything. And for defending these things, Canada was disputing and went to the DSP, Dispute Settlements Board. Our study analyzes the case between the brief facts of the case, legal issues raised between Australia and the Canada disputes, and finally it tries to focus on the impact of the case of international trade and international law. The study shows the pros and cons of the case and its impact on international trade and enterprise, what results were brought by the disputes between them. So other things will be, thank you from my side, other things will be discussed from my friend Mahmoud. Thank you so much.
Hello, good afternoon guys. I'm going to talk about the dispute between Canada and Australia regarding the banning of the importation of salmon. So the thing happened on October 5, 1995. Australia banned Canada to import the salmon to Australia, and they couldn't actually prove enough reasons and evidence. And they just said like, we are having disease and having problem, but they couldn't make enough evidence for their side. So Canada go to the WTO, World Trade Organization, and they complained that actually Australia is actually not following the measures of international business rules. So they are having conflicts and everything. At the end of the day, like they went to the different in order to obtain the right of the measurement. Actually, the Canada asked what's the exact measurement. What's the exact measurement to measure, like if our salmon is good or not good. So they went to the WTO panel, and India, China, Norway, and European communities, they played the third-party role. So they went to, they actually formed a group, and on 7th March 1997, the panel took a little bit longer time, and that's made Canada a little bit upset. But on 2002, on 22 July 1998, Australia showed that we actually appealed against the certain complaints about these issues. And then an appeal body was established October 20, 1998. And on 18 February 2000, the complaints panel found Australia violated the certain articles of SPS agreement. And then Canada requested to the curricular activity guys to fix the issues, and Australia then wanted to leave the issues. But Canada were forcing, no, we want our problem to be solved. And on 18 May 2000, Canada declared we have reached on a mutual agreement, and that's how actually they got the problem solved. So the next part will gonna be covered by my friend.
Alright, as my friend has already discussed about the case, which was a dispute regarding the importation of salmon from Canada and exporting their salmon from Canada to Australia. But the legal aspects, as a student of legal aspects and enterprises, had to be noticed about some of the legal aspects. So what actually was happening there, and from the both of the parties' aspect.
Yeah.
Well, the legal aspects presented by both of the parties are, like, for example, from the Canada, they have been telling that Australia is violating the WTO compliance, which the country could export and import the goods from each other, and also the SBS agreement. And they also made a complaint about the DSB, which is Dispute Settlement Board panel recommendation non-compliance and lack of evidence for the reasoning of why actually the Canadian salmon were being stopped to be imported in Australia. Similarly, from the side of Australia, the Australian authorities has been accusing or just banning that product to Australia because that is quarantine regulations, and that is hazardous in terms of health and safety, and as well as it is in the favor of arbitrage. Those were the aspects that were discussed by both of the parties. And similarly, individual argument raised from the parties were a bit kind of brief description about the legal issues. That is, arguments from Canada is non-compliance or the violation of WTO article under the international trade, and non-compliance of SPS agreement, and also no evidence of risk assessment and compliant why actually the product is harmful, that has not been assessed. And from the side of Australian parties, they say that that is the regulation we have within the country that has to be very much implemented rather than giving a bit focus for the international treaties apart from complying with our home regulations. That is the one. And the other one is health and safety as a prime concern that they were very much conscious about, which that the imported goods might have in the community of the Australian society. And also they are in favor of arbitrage for settling the dispute. And decision about the case will be discussed by my friend Mohammed.
Thanks, my friend. Now I am going for a discussion about the tribunals. And firstly, the DSD plan had the found evaluation in certain articles WTO and SPS agreement. The next one is it has a recommended withdrawal of the ban that has imposed by Canada by Australia. And Australia requests to settle the case through the arbitration process according to selection 22.6 and of the BSB regulations. And as a result, the DSD panel, they approved the arbitration process and the employee arbiters for the recognizing among the parties. In case 2000, the Canada had declared that they had reached into the mutual agreement and regarding this issue. Now I would like to call my friend Deepti. He is speaking our next slide, significance of the case of information law and the conclusion. Thanks.
My name is Deepti. My student ID is EMV20781. Today I am going to talk about significance of the case in international law. The case has specific significance in international trade law. It provides learning to the countries that before banning the trade of a country, proper risk assessment and evidence should be completed. It can support obtaining favor from the trial. It will also support to comply with the laws of international trade, such as complying with WTO articles and SPS agreements. Before banning trade on certain countries, proper risk assessment and supportive legal evidence should be completed. It provides significant learning that arbitrage process can resolve the disputes arises between the parties more conveniently and satisfactorily. It also saves both time and cost of negotiation and judgment. And next one is conclusion. International trade law and business depends on certain laws and convenience that are agreed upon by the countries of the world. That is why the violation of the international trade laws and regulations stand the countries in front of the court. In the given case, Australia banned the importation of fresh salmon from Canada, which lessens and denies the fundamental right and ignore the impaired benefit of Canada, which is provided by the SPA agreement. As a result, Canada sued against Australia to the DSB, and the board found a significant violation of articles of WTO and SPS agreements. Finally, The dispute was resolved by the arbitration process requested by Australia. Thank you.